Bridget Loving and Mildred Jeter were family friends who grew up 3 to 4 miles apart in a relatively mixed community that saw themselves as family regardless of race. Bridget Loving was a young white man who had a passion for revving up engines and a drag car racing. Mildred was a shy, soft-spoken African woman with Native American descent who became a reluctant activist in the civil rights movement of the 1960s. In the year 1958, these two lovebirds decided to travel to Washington, D.C. to marry, where it was legal for interracial marriage, leaving their family and friends behind.
Although, after the wedding, Mildred never felt comfortable being a city girl and wanted to see her family once again. They returned back to Virginia and took precautions to not be seen with one another and would often stay at home. Although on July 11, 1958, Sheriff R. Garnett Brooks questioned the couple by breaking into their home at 2 a.m. asking, "What are you doing in bed with this woman?" The couple had been together for 5 weeks, and Mildred responded with, "I'm his wife." It was a crime. Her husband spent the night in jail, while Mildred spent 3 nights more in her small cell that could only fit one person. After the couple pled guilty, the presiding judge, Leon M. Bazile, gave them a choice: leave Virginia for 25 years or go to prison. They left and would spend the next 9 years in exile. In 1967, the case reached the Supreme Court. Petitioner Philip Hirschkopf argued how the only issue that the court should be deciding is, may a state make marriage between two consenting adults illegal because they do not share the same race? He gave the court some background about the marriage laws going back to the 1600s and how the law was meant to avoid white women from being involved with black men in order to preserve white purity for the black woman. The law was meant for self-worth of the black woman in order to prevent them to feel as if they were in a lower social position and a lower economic position. He continues to say how marriages between Negroes and whites are criminally punished, which means that the state is not concerned with the racial integrity, but the racial supremacy of the white race. Bernard Cohen began to argue how the law of the Virginia preventing the Lovings to get married and to live in the state was a violation of the 14th Amendment. He argues that the marriage is a right of liberty to all citizens, which is within the 9th Amendment and the Due Process Clause. Cohen stated that the Due Process Clause has been an issue in many cases and that all of the cases apply to the Lovings case. Respondent McIlwain began his statement by calling out the argument Hirschkopf had given. He explained how it may be true that there are only legal repercussions for black and whites to marry each other, and not other races. It is because there is no insignificant amount of other races in Virginia, but says that there has been no effect on the state's anti-miscegenation laws in the history of the 14th Amendment. Therefore, the court does not have the right to take away powers given to the states.
In the end, the judges unanimously decided to reverse the judgment of the Supreme Court of Appeals. This was a decision that struck down laws against interracial marriage in 16 U.S. states. Because the decision was unanimous, there are no dissenting opinions. The majority opinion was written by former Chief Justice Earl Warren and signed by all other judges. In his opinion, Warren addressed the Virginia statute punishing interracial marriage, calling it unconstitutional. Warren addressed each of the state's arguments, asserting that there was no rational basis for the racial classifications and that distinctions based on ancestry directly conflict the doctrine of equality that the Constitution is based on. Warren also cited the 14th Amendment, firmly stating the clear and central purpose of the 14th Amendment is to eliminate all official state sources of invidious racial discrimination in the states. Finally, Warren closes the opinion by stating that Virginia's marital restrictions deprives the Lovings of their due process right to marry, which is a basic civil right of man. In the end, the judges unanimously decided to reverse the judgment of the Supreme Court of Appeals. This was a decision that struck down laws against interracial marriage in 16 U.S. states. Because the decision was unanimous, there are no dissenting opinions. Though the majority opinion was signed by every justice, Associate Justice Potter Stewart did write a brief 2-sentence concurring opinion in which he stated that it was impossible for a state law to be valid under the Constitution if the criminality of the action depended on a person's race.
Loving v. Virginia is considered one of the most significant legal decisions of the Civil Rights era. The Supreme Court entered laws prohibiting on interracial marriage as violations of the Equal Protection and due process clauses of the 14th Amendment of the United States Constitution. Americans no longer could be prohibited from marrying based on race. By declaring the anti-miscegenous law unconstitutional, made it possible for families like President Obama, which consisted of his black African father and white American mother, to legally exist in the state nearest to the city that the president and his family now call home. It also drives the gay marriage debate. The Loving case has been repeatedly cited by supporters of gay marriage as one of the most substantive legal arguments for legalizing same-sex marriage in America. It fueled the rise of multiracial families. Multiracial Americans like President Obama and Ben Jealous now constitute the fastest growing population in the country, thanks to the explosive increase in interracial marriages in recent years. The number of marriages made up of people of more than one race has climbed from 3.2% of U.S. marriages in 1980 to 8.4% today, or 1 out of 12 marriages.